because a Warren County district attorney seeks a preliminary injunction in a lawsuit over guns and medical marijuana. That's right. The Warren County district attorney wants a judge in federal court in Erie to rule sooner rather than later in its potentially precedent-setting case that seeks to upend federal law over gun possession and the use of medical marijuana. Rob Greene is seeking a preliminary injunction that would halt a federal policy that prohibits him from having a firearm as long as he has a Pennsylvania medical marijuana card. Greene wants a preliminary injunction in place while Pittsburgh-based U.S. District Judge Kathy Bison considers the lawsuit that Greene and the Washington State-based Second Amendment Foundation filed in January in U.S. District Court in Erie. They are suing the United States government, Attorney General Merrick Garland, and the directors of the FBI and the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The suit is over the federal law that prohibits the users of marijuana, including medical marijuana, from having firearms, even if a user's state has legalized medical marijuana, as have Pennsylvania and 37 other states, as well as 3 territories and the District of Columbia. Greene, a Republican first elected in 2013, said in December that he would not run for re-election when his term expires in 2025. He said he would advocate for legalization and regulation of cannabis, and the advocacy expanded into court while the filing of his lawsuit on January 23rd and with his request for a preliminary injunction. The lawsuit asked Bison to permanently enjoin the enforcement of the marijuana-related prohibition. The suit claims the ban violates Greene's Second Amendment rights to bear arms, and in his motion for a preliminary injunction filed on Tuesday, Greene requests that Bison block the ban temporarily as she considers his underlying lawsuit. The request for a preliminary injunction is all but certain to result in more court attention to Greene's case, and a lawyer with the U.S. Justice Department filed the notice on March 7th that he is representing the government in the lawsuit. The notice said he was waiting to be served with the suit before he answers it in court, and the government now will also have to respond to the more pressing request for a preliminary injunction. Greene's lawyers are arguing that a preliminary injunction would halt the irreparable injury to Greene's constitutional rights due to his inability to possess weapons at the same time he uses medical marijuana, according to a brief filed with the motion for the preliminary injunction. And Greene got a medical marijuana card in May of 2023, according to his suit. The suit provides no information on his health, and Greene and others who use medical marijuana, in quotes, are currently being deprived and would continue to be deprived of their fundamental right to keep and bear arms, according to the brief for the preliminary injunction. And Greene, the chief law enforcement officer in the largely rural 38,000 resident Warren County, is abstaining from buying or possessing firearms to avoid prosecution, according to the brief. It states that that 500,000 Pennsylvanians who use medical marijuana are prohibited from having guns under federal law. And the conflict between state and federal law exists because marijuana is not legal nationwide, and it remains a Schedule I drug along with other substances, yada, yada, yada. Greene's brief also states that he is not seeking to use firearms while under the effects of medical marijuana, and he is solely seeking an ability to purchase, possess, and utilize firearms and ammunition when not utilizing doctor-recommended medical marijuana. No different than a patient that has been prescribed such painkillers as diluted diamorphine, hydrocodone, morphine, oxycodone, according to the brief. And it states that Greene has never used medical marijuana while in his official capacity as a district attorney. And the group believes the case is a first of its kind. Hold on, it gets better, Dale. Hold on. The Second Amendment Foundation Executive Director Adam Kraut, a lawyer who is representing Greene, said in an interview that the case is the first of its kind that he knows of the challenges that federal firearms prohibition in the context of a medical marijuana card. And in quotes, he says, due to the law Individuals are placed in untenable situations of having to choose whether to use a medicine recommended to them by a doctor to treat their symptoms at the expense of their Second Amendment rights, or exercise their rights at the detriment of their health, Kraut said in a statement. And he also says, having to make such a choice is simply wrong, and we look forward to vindicating the rights of these affected. The Second Amendment Foundation is a plaintiff with Greene in the suit, along with a resident of Bloomsburg, Pennsylvania, James Erie, and he was added as a plaintiff in an amended lawsuit filed on March 6th, and the case is docketed in the U.S. court in Erie because Warren County, the home of Greene as the lead plaintiff, is one of 7 northwestern Pennsylvania counties with the Erie division of the Pittsburgh-based U.S. District Court for the Western District of Pennsylvania. Dale, man, I think this guy has a case. What do you think about this?
Well, the first thing that they look at is your likelihood of success on the case, because if you're arguing that I have a Second Amendment right and there's irreparable harm being done to me, you've got to at least make a facial showing that I'm going to probably win on this case if we go into a substantive battle. And the Supreme Court made it very clear that they're going to look historically on how the Second Amendment was treated with respect to not allowing people to have guns with certain conditions, okay? And historically, there was none of this until recently, okay, in the recent history of this country, where now all of a sudden, if you use an illegal drug, now we're going to ban you, as opposed to using that same drug that you acquire legally. There's a lot of nuance in here, but I would expect that this judge would take very seriously slapping this with a preliminary injunction to stop this now, which is going to put ATF in a tither, because now they're going to have to take a look at that form that they make you fill out. And what do you do about that? Because it asks you, are you an illegal user? And first of all, I think that's a Fifth Amendment violation, but I think that there's a good chance they're going to get a preliminary injunction here, and this is going to move forward. And they may even go on to a bigger hearing about a permanent injunction to stop them, as part of arguing this violates my Second Amendment. It then throws the ball into the government's court to prove that this is necessary for them to carry out a very fundamental government purpose, okay? And they can't connect those dots. You don't have to stop people smoking weed from getting a gun to fill out any fundamental, governmental purpose here. That's horseshit. Well, I'll be interested to see how they parse this out as it goes through the system. I think the Supreme Court's going to just tear this shit up and throw it out and go, you guys need to start over again.
Really? You think that you don't think that they'll rule on it?
Well, first of all, there's a long ways to go. We're at the district court level here. And I think a district court judge, given the precedent recently set by the Supreme Court, that if you can't prove historically this is what we've done with the Second Amendment, we're not going to let you do it. Okay, well, I don't think the government wins that battle.
Well, let's just say the government argues that battle. Do you know what I would argue as a counter argument to whatever their argument would be, Dale? Is the fact,
you would argue?
Yeah, 100%.
Okay.
Yeah, I would argue the fact that that if we're going to go back to that and make the forefathers as the measurement of whether or not substances or whatnot, we all know that George Washington and Thomas Jefferson used to host a seed exchange at the White House and grew hemp, which is all the same definition of cannabis sativa L. So therefore, it's all the same thing, and they were growing it, and so they definitely didn't have a ban on it with guns back then if they were growing it.
Let's not even say they weren't growing shit. Their slaves were growing shit. Their slaves were growing all that.
Oh, there we go.
Let's keep it above.
Okay.
There we go.
But the issue that the government's going to face is that the first time marijuana was federally illegal was in 1937. That was a couple of days after we started this country, okay? And the first time that they made the use of an illegal substance a reason to take away your Second Amendment rights is when since I was became an adult, which is a long time ago, but not near like 1937. So this is all very recent stuff to say that, this justifies taking away our Second Amendment rights. Based upon what the Supreme Court has said, I don't think they have a snowball's chance in hell if the court applies the federal the Supreme Court's precedent here.
Mm-hmm.
Hey, but we'll see. I would hope they would throw in a preliminary injunction out there and halt this shit and make the government go, oh my God, what happens if we lose this case? And maybe accelerate the DEA getting out of the way and moving this over to ATF or something like that. But I think it's all going to be part of this crumbling, because I think if the Supreme Court gets the question of what do we do with marijuana, Clarence Thomas has already signaled what he's going to do. Mm-hmm. I think he has enough of a majority on that court that'll say this has got medical purpose to it. What you did, they're not going to say horse shit. They'll use the King's English here. Mm-hmm. But they say this is not supportable, and all this stuff violates people's constitutional rights to freedom, and throw it out.
Mm-hmm. I
love that.
Yeah, that would be the
On that
best.
note,
That's how we would
I think
win.
we should wrap it up.
Let's do it.